Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss legal victories and challenges to your fundamental freedom and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, founder and chairman of Liberty Counsel, explains the latest legal issues all across this country. In the courtrooms of America, Liberty Counsel is winning the battle for your constitutional freedom.
What are the implications of the Supreme Court's decisions on the marriage cases? We're going to pick that topic up today on Faith and Freedom. I'm Matt Staver, founder and chairman of Liberty Counsel. Joining me is Matt Barber, vice president of Liberty Counsel Action. Matt, the Supreme Court decided Proposition 8 and also the Federal Defense of Marriage Act case. Obviously, the implications for the Defense of Marriage Act case is that for federal purposes, that definition is struck down as unconstitutional. I use that in quotes. And that means that any individual that's in a state that recognizes same-sex marriage can have joint income tax returns, even though they're in a same-sex relationship. They can have Social Security and other kinds of benefits. But the questions remain unanswered in many of these situations. What happens if somebody from Massachusetts now moves to Florida, which does not recognize same-sex marriage, or Virginia, which does not recognize same-sex marriage, and in fact has it in their constitution, and now they want to claim a federal benefit? What happens if they want to have that state recognize their own same-sex marriage? I think we're going to have a lot of litigation on this issue. And I think this court's decision has laid the groundwork to try to undermine these marriage amendments.
Oh, this is going to keep the coffers flowing for Lambda Legal and other homosexual activist attorneys. The lawsuits, the floodgates have just been opened for lawsuits. I mean, just the marriage issues alone could clog up the dockets in courts around the country for a long, long time. But Matt, you know, this puts people who simply acknowledge the reality that marriage is between a man and a woman, whatever their motive, if it's because they're a Christian and because, you know, that's Christ's definition, God's definition for marriage, or if it's just because they recognize natural law and that this is reality, people are going to have to draw a line in the sand. We're saying this is a line we cannot cross. So this decision puts Christians, for instance, in an untenable position. We either have to pretend that marriage is something it's not and be in disobedience to Christ and his definition, or stand firm on our faith and our belief and be willing to accept the consequences for saying, no, I will not cross that line. I personally will not cross the line.
No, I know. It's like somebody who's got a bed and breakfast, or somebody who's operating a pastry shop or a duplicating shop. Are being forced now, and some people in various employment situations, even in the Department of Justice, are being forced to accept this as normative. This is a line that Christians and people of faith cannot cross, and people of moral values cannot cross. This is the collision that's coming. You know, this if under this particular ruling, the Federal Defense of Marriage Act ruling, if there's 5 justices that say it's bigoted and hateful to have a definition of marriage that affirms the long-standing understanding of marriage as one man and one woman, for federal purposes, it's just a matter of time before those are challenges that are now going to go into the other courts to challenge the other part of DOMA, the part that says one state does not have to give recognition to an out-of-state same-sex marriage. That you've got someone coming from Massachusetts, for example, to Virginia or Florida and saying, I want my same-sex marriage recognized. Well, for Justice Kennedy, I think he would ultimately go down that road. I think you'd have a majority of justices to go down that road. I think also you'll have for this litigation, if we go down the road and adopt same-sex marriage, you're going to have religious persecution. To me, what this decision is, it's the 1972 contraception for unmarried couples decision to the 1973 abortion decision. And it was on that basis that the Supreme Court built the abortion decision. I think that's what this decision is today, or this decision is from the Supreme Court. Yeah,
that's a great legal analogy. The reality as it stands right now, if there's any silver lining whatsoever, and it's a very thin one and a very precarious one at that, is this. It's that still today, right now, in 37 states, marriage is defined as marriage has always been between a man and a woman. 13 states in the District of Columbia now imagine this mock marriage thing, gay marriage, that it exists for legal purposes. That's where it stands now. I'm not convinced, as you mentioned, that Justice Kennedy is willing to take the strong Federalist position that he tried to feign with this DOMA decision that would keep him from wiping those 37 states off the map in terms of their definition of marriage.
I'm sure I agree with you 100%. You know, on the Proposition 8 case, what they ultimately decided on that case is that the initiative supporters of Proposition 8 lack standing. So therefore, they didn't have a right to appeal it to the Court of Appeals nor to the Supreme Court of the United States. That when the decision was decided by Von Walker at the trial court level, decision that was in agreement with the plaintiffs, and then the decision that the state attorney general also agreed with, that the controversy, the case was over. Yeah. You couldn't take it any further because there was no more adversarial process. That means that the Ninth Circuit Court of Appeals is vacated, set aside, which is good news. But what happens is the Northern District of California, where this court sat, is still the law of that particular jurisdiction. Now, you've got three different districts in California. You got the Southern District, which is the greater San Diego area and the surrounding counties. You got the Middle District, the Los Angeles greater area and the surrounding counties. And you got the Northern District, the San Francisco area and the greater surrounding counties. The Southern and Middle Districts are not affected. But no doubt, what the people in California are going to do, the government, is try to enforce the Northern District ruling on the rest of the state.
It's already happening.
And they're going to do that. And then there's going to be arguments, and there's going to be court cases, and it'll go back up through the court system, and it'll ultimately go back to the U.S. Supreme Court.
Yeah, Jerry Brown has already said within 30 days he wants all clerks across the state of California handing out same-sex marriage licenses. So but in a nation when the Supreme Court is signaling, hey, we're going to do whatever we want to do, we've essentially become a lawless nation at this point where we're not a constitutional republic. We're unrecognizable based on this decision. It's been building up to this, Matt. But talking about that Prop 8 case, something that we need to mention here, we'd be remiss if we didn't, is the disastrous precedent that is set now in terms of an absolute veto that is given to the executive branch of any state government. If they don't like a law that is passed through either their own state legislature or through ballot initiative, even a constitutional amendment, as Prop 8 was through the ballot initiative, 7 million people passed it into law. All the executive has to do, the Attorney General executive, say, hey, we don't like the law, so we're not going to defend it. And the Supreme Court is now saying they get the heckler's veto,
all they have to do is get someone, and they collude with a plaintiff to bring a lawsuit.
Yeah.
And this administration has been colluding with plaintiffs in the abortion context, no doubt, and no doubt in the same-sex marriage context. Colluding with them, they ultimately sue. The defense then actually just simply says, I agree with you, and they get a judge that says, okay, we're going to strike it down. I saw this happening out in the West with the state attorney general and some same-sex plaintiffs, where they actually had previously agreed to actually go into court, have them file suit, and they were going to capitulate.
That is unethical. The unethical nature of that. I mean, we should be talking about people being disbarred.
Yeah, because you can't. When the legislature passes a law, you're supposed to defend it.
There's a duty.
But, the fact is here, when they collude and set up situations like this, they bypass the people. What ultimately happens is when the court gets out of control, and this is what Thomas Jefferson said, is that it has the seeds that bring about the dissolution of the republic. If the court ultimately does not restrain itself and exercise its own judicial restraint, if it becomes this unfettered, freewheeling, ideological machine, it undermines the other two branches of government and thus begins to dissolve the actual republic itself.
Well, that's exactly what we see happening here. It's chilling. We are entering the phase where we are no longer a constitutional republic. We're a banana republic in the United States of America.
I encourage you to go to Liberty Counsel's website, order Original Intent by David Barton. The Supreme Court justices, or some of them, may not respect or understand the history of this country, and if they do, they certainly want to run from it. But I encourage you to learn about it. That it can be done by many good resources, one of which is Original Intent by David Barton. Also sign the Marriage Solidarity Statement, marriagesolidarity.com. A number of leaders around the country have done so concerning the importance of marriage and the fact that this is a line that we cannot and will not cross. That's marriagesolidarity.com. Also, Liberty Counsel has been involved in this case and many other cases around the country, defending nearly 50 cases involving marriage. We were involved in the litigation in California from 2004 to 2008. And we filed a brief in this particular case, in both of these cases, before the High Court. We can only do so by your prayers and your continued financial support. You can go to Liberty Counsel's website to make an online credit card contribution, and also sign up for our Liberty Alert and Liberator newsletter and make a contribution to help support and advance this mission.
You have been listening to Faith and Freedom with Liberty Counsel. We hope that we have motivated you to stand up for your faith, family, and freedom. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email updates. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.